Hey, it is 2 p.m. So I will call the December 13, 2023 meeting of the Court Reporters Board back to order. We will start up again with agenda item 8, the 2024 to 29 strategic plan. Ms. Fenner, would you like to give us the background for this item, please?
Thank you, Chair Tugade. Before you is the proposed strategic plan for 24 through 28. As a reminder, this is the overarching goals of the board. Once the plan is approved, staff will meet with solid staff to develop an action plan by breaking down each objective into smaller action items, including who is responsible for the completion and when it is to be accomplished. So we will need a motion to approve, but this is your chance to make any amendments. Thank you.
Ms. Brewer.
Okay, not surprisingly, probably I just have a couple of things that I noted. On page 101, I just wanted to highlight to verify and make sure that these numbers in the second to last paragraph are up to date. The 5,580 licensees and 210 registered court reporting firms. I think I saw elsewhere that was listed as 213. And so just a note to bring that up to date. And then a couple of changes on the second line of that same paragraph. I would put commas after the word officials and the word freelancers. And I would add, after who, I would add generally work through court reporting agencies. I don't know how important it is that we have this, this minutia taken care of in this strategic plan, but I've only got a couple of things. The next page, 102. Third line from the bottom, I would delete the word "and" before input, because it looks like this is a series and there's an "and" before working meetings at the end of the line. And page 103. Oh, page 103 under vision, the last line, I would delete the comma after knowledgeable, most knowledgeable and ethical. And 107. Oh, I just made a comment that I think these points, the way they're outlined under outreach, they're all excellent points. I was wondering, we had a little discussion about trying to promote the TRF, and I don't know if that's anything that we'd want to include here. Interested in what other board members think, or if that's not a point that we have there, fine. At the start of that page.
4.4 addresses the TRF.
Yep. Can I
increase awareness? There it is. Great.
I think part of the confusion, and one of my I have a few suggestions too when after you get through them all, but on this one specifically, I thought 4.4 and 4.6 were somewhat, or 4.8, sorry, 4.4 and 4.8 were somewhat related. I didn't know if they were redundant. And the word address in the beginning of 4.4 is a little confusing. What do we mean by address? And I proposed maybe we change that to promote instead of address, promote the transcript reimbursement fund. So. And again, talking about goal 4, yeah, 4.
Thank you, Mr. Dodge. Ma'am. Yeah, I agree maybe address is not the right word there, but I wonder if there's a broader word than promote that would allow us to to classify a larger number of actions under that under that bullet. Ms. Sunkis?
I would first say those are two separate issues, in my opinion. So I think they're well taken. They're two different points. Explore and possibly explore ways the TRF for the TRF, explore avenues for the TRF. I guess both of those, they run into the same problem with to increase, explore ways to increase awareness and inclusivity. I don't know.
Of the trans reimbursement fund. Yeah.
Right. Our wordsmiths heads down. I can see the wheels spinning.
Wordsmiths, do you feel like you have enough there to kind of change that, to change it from address to more around that explore ways to increase awareness and inclusivity of the transcript reimbursement fund?
Are you talking about 4.4?
Yes.
Doesn't it become 4.8 then?
I think number 4 is about raising awareness of the fund, and number 8 is about increasing funding.
Gotcha.
On the wording on 4.8, I don't know that. I will be honest, I'm not too concerned about
Sure.
the wordsmithing there. But well, again, we'll defer Ms. Fenner. Ms. Sunkis?
I'm suggesting perhaps 4.4 just be increase awareness inclusivity of the transcript reimbursement fund.
Yep, that works.
And I think 4.8 is fine.
Yep, no change there. Just wanted to clarify if we want to keep them separate, which sounds like we do, which is totally fine. Can I ask about, if we're done with that, can I ask about 4.5?
Go ahead, Mr. Dodgen.
It says attract people to the profession to address the shortage of licensees. That's fantastic, and that should be the goal. I don't know if that's too big of a task or too heavy of a lift. If instead we want to say something, I hate we keep using it, but explore ways to attract people to the fund, to it, or if we're fine with the way it is. But I think on its own, it's a pretty heavy lift, and I'm not sure we know how to do that. So I think we have to explore ways to do it.
That would be the action plan. So I think that this is as a good broad goal.
Great.
A strategic target, if you will, then I think it fits. And then we will bring back to you how we envision getting there.
Wonderful. Yep. And that's fine.
I wonder if, to Ms. Brewer's earlier point, it is worth removing that sentence, attract people to the profession, or that clause, and just saying explore ways to address the shortage, because in some ways the issue is not necessarily the number of there's some issues in the flow of the workforce, not necessarily the workforce itself. Ms. Fenner?
As I recall the discussion at strategic planning, though, the focus was on advertising the profession and attracting people to the profession I don't think that the shortage of the licensees was like the main focus of that part of the discussion. I could be wrong.
Ms. Sunkeys.
Yeah, I agree with what Ms. Finner just said. In fact, I've got a note here, update the student career brochure. And I understand that will come with the action plan, but so I agree that this is more, I'm fine with 4.5.
Other board comments? Okay, I'm happy to withdraw my suggestion. Any other board comments?
On that specific item? No. No.
Or maybe on page 10 of the strategic plan, page 107 in our packet before we move on, Ms. Brewer. Go ahead, Ms. Brewer.
So my only comment that I wrote was on page 108, implementing online renewal. Now I know that's in the works. Seems like that's administration, maybe not, maybe, yeah, maybe administration.
I'm unsure what you're suggesting, Ms. Brewer.
Ms. Sunkeys?
I have the same comment. I'm not following.
So under administration, okay, streamline transcript reimbursement, create succession plan, collect data and website traffic to assist the board in improving. I guess maybe this is too much down in the weeds, but implement online renewal for licensees. Or is that action plan material?
Well, we already have that, right?
It's in the works. So
You can renew online right now, but we are bringing the process off of legacy systems onto a new database, new program.
okay, so scratch that. Thank you.
Great. So,
Mr. Dodgenham?
regarding all of the strategic items, the strategic initiatives, I went through and there were a couple that I just wanted to double check. My overall effort or thought here is to help streamline the process when it gets turned over to Solid and we work in the staff to kind of work on the plan. So one is I wanted to try and consolidate, make sure we still agree with everything on here, or are there some things that might drop off in an effort to kind of streamline and focus on a few really important things. Probably most of them will stay, but there's a couple I want to highlight. And then also, I wanted to propose again to make it easier for the next stage, if we might prioritize some of these, say which of these are the highest on the list down to the lowest. And I think most of them are kind of ranked in pretty high in priority order, but there's a few that I propose kind of changing the ranking. So if that's okay, I'll start with goal 1, if do that. So the first one was I wanted to check again, are we still interested in the number 1.5 was explore the possibility of provisional licensing to promote fully licensed reporters and address the shortage of licensees. I remember even when we had this discussion, there was a little bit of controversy of what we meant by that professional licensing, which I think maybe why we were exploring it. But that's still something important that we want to do?
Yes, from Robin.
Okay, if one person does, then we keep it on. Great. So we'll keep that, thank you. And then I had a question on number 1.6. It says pursue legislation that would require certified shorthand reporters to complete continuing education. We've done that a few times. Is that still something we want to keep trying to do on that one? Great, okay. So on these ones, I was gonna propose, I think 1 through 4 are in the right order. But I thought the fifth one on demographic data might be, since it's a little bit more actual, we might make that 5 and then make 1.5 number 6 and 1.6 number 7. So just kind of bump that one up. There's no objection.
Could you say that again, please? I didn't follow. I was looking down.
Sure, I'm sorry. If we assume that they're in ranked order of priority, I wanted to take number 1.7 and put it after 1.4. So it would be the 5th one instead of the 7th one. And all the other two, the remaining 2 would drop down 1. And again, it's just assuming a rough prioritization if everyone kind of agrees. This.
May I comment?
Oh, sure, Ms. Burr.
Please.
So I believe that the provisional licensing is something that's meant to address the shortage, which is critical. So I would be in favor of putting 1.7, of switching 1.7 and 1.6. Or I'd be okay with that. But
that's great.
I like,
Yep.
I think the provisional licensing is a more important, touches on a more important issue.
Ms. Fenner?
Is it even more important than 1.4, the reinstatement of last licenses, or?
Before we continue the discussion, I think Ms. Fenner was going to jump in because I don't know that the assumption that these bullet points are actually ranked by, internally. I think we can discuss, or not, I guess, internally, but we can have that thought process. But ultimately, for the purposes of solid, and Ms. Fenner, correct me if I'm wrong, but generally these carry the same weight.
Yep. The only thing that would be helpful, rather than spending time trying to rank them, is if anybody has something that jumps out at them as this particular one should be high priority. And then when we put the action plan together, we can move that to the top of the list on the timeline. But I don't see any purpose in reordering the list, or it's just what staff would need to take away for the preparation of the action plan is if you have an item among those that are listed that you think deserve more high priority.
Yep. Okay. Yep. No, that makes more sense. Thank you. And I should have given more opportunity to discuss that strategy. So I totally agree with that. On that note, could I propose number on, and I do have a couple of questions still on some of the others. I want clarity, but on goal number 5, administration, I think creating a succession planning is probably a higher priority than the other 2, which are a little bit more aspirational. So we just want to put that on a higher priority of all administrative tasks. I think I've got 1 or 2 others I'll find, but I did have some questions on, let's see, sorry, let me find my notes here. Pursue a license with meal. Oh yeah. I had a question on goal 4 on outreach on page 107. And this is 4.6. It says pursue legislation that would require licensees to provide an email address. And I just wanted to check on that to make sure, is that anything that we can do with regulation, or does that absolutely require legislation?
It requires legislation, but it's non-controversial. So that's why we're including it as an ask within the Sunset Review report.
Great. Okay. Thank you. All right. That's all I have right now. Thank you for indulging.
Thank you, Mr. Dodgenham. I had seen a hand up from Ms. Sunkeys. Okay, great.
Yeah, my question was addressed.
Great. So, Mr. Dodgenham, your hand is up again. Did you have additional comments?
Nope. Thank you. I'll just take that down. Thank you.
Other board comments? With that, are there any further comments on the strategic plan? Ms. Fenner, do you need any additional direction?
There's motion language on page 97 for approval of the draft so we can finalize it.
Okay. With that, I will take a motion to approve the finalized report or the finalized strategic plan as amended. Ms. Unkeys.
I move approval of the 2024 to 2028 strategic plan as amended.
Thank you, Ms. Unkeys. Do I have a second? Ms. Brewer, thank you. Okay. And with that, we will take public comment.
This is the moderator. The Q&A is now open. The instructions are on the screen for your reference. If you are logged in and would like to participate, click that question mark inside of the square, typically located bottom right corner of your WebEx screen, and type the word comment in the text field and send it to all panelists. If you're calling in via a phone, press *3 to raise your virtual hand. At this time, I see no requests for public comment. Madam Chair, would you like me to close the Q&A feature?
Please, thank you, moderator. Ms. Burning, would you please call the roll?
Yes, thank you. Ms. Brewer?
Aye.
Thank you. Mr. Dodgenham?
Aye.
Thank you. Mr. Manayan? Ms. Sunkeys?
Aye.
Thank you. Ms. Chagade?
Aye.
Thank you. One more time, Mr. Manayan? Hearing nothing from Mr. Manayan, motion carries.
Thank you, Ms. Burning. With that, we will move to agenda item 9, expedited fees for deposition. This item is back before this board. At the last meeting, we had asked staff counsel for additional analysis, which begins on page 112 of the board meeting materials. Ms. Fenner, would you frame the board's discussion with regard to final outcome?
Yeah, actually, I don't have anything to add to the information from the last meeting, but I do know that our staff counsel has some information for the board, so I will cede to Ms. Joffrey.
Thank you. So before we begin with my legal summary, I wanted to, one moment, reiterate the Open Meeting Act guidance from the last meeting. Oversight of fees can be a heated concept. It requires the board to balance protection of the public, statutory compliance, and legislative intent in a way that could affect licensee income. The board is composed of licensees and public members to provide their perspectives on the oversight of this industry. Every member has an equal role. Moreover, the board listens to and considers comments made by the public. Then the members vote, and the Court Reporters Board of California speaks as one. Business and Professions Code, Section 8005.1, provides that the Court Reporters Board shall license, regulate, and discipline those within its jurisdiction, and provides that the protection of the public shall be this board's highest priority. Also, Business and Professions Code, Section 8015, states that the laws providing oversight of this industry are designed to establish and maintain the competency of court reporters for the protection of the public in general and for the protection of litigants in particular. As with all items on the agenda, the Bagley-Keene Open Meetings Act requires orderly conduct to accomplish the people's business. Participation by the public and each member is highly encouraged as long as it remains orderly. Before I provide a summary of my research, do any of the board members have any questions regarding the Open Meeting Act? At the September 2023 board meeting, the board was briefed on the need for codification of the professional conduct policy regarding the expedited deposition transcript fees. The matters before the court in this issue included fees deemed unconscionable, and the board staff receives consistent complaints of excessive fees. Licensees need to know what is expected for professional conduct standards, and the board must enforce professional conduct by its licensees. The board determined in September that it required additional context to make an informed decision as to the policy it wished to implement and the codification process it should pursue. Any party may request expedited transcripts regardless of as to who noticed the deposition. For simplicity, however, the party not requesting an expedited transcript will be referred to as the copy party. In the hypothetical provided in the public documents, Party A and Party B are attending a deposition noticed by Party A. The court reporter provides the cost of transcripts and then when the transcripts will be made available. Party A asks for expedited transcripts and accepts the expedited fee. The question before the board is, may the court reporter also charge Party B, who did not request the expedited transcript but has a right to receive access to the transcript at the same time as Party A? Statutes do not reference expedited deposition transcript services. Code of Civil Procedure, Section 2025-510, provides in Subdivision B, the noticing party shall bear the cost of transcription unless a court orders otherwise. In Subdivision C, the other party may pay to obtain a copy, and in Subdivision D, the transcript shall be made available to all parties at the same time. The statute provides that any service related to the transcription of deposition services are those regulated by this board. I also reviewed case law. In 1997, the state appellate court found that in the Union Pacific case that while the fees to the copy party were excessive and unconscionable, without law, there was nothing the court could do to remedy the situation. Transcription costs were a matter of what the market could bear. In 2008, the state appellate court reviewed these types of fees and heard what is known as Stephan 1. The trial court in that matter had again found that the court reporter's expedited deposition transcript fees to a copy party were unconscionable, but following Union Pacific case, the court could not provide a remedy. The appellate court found that the court did have the authority to provide a remedy to unreasonable fees. The court rejected Union Pacific's findings that the costs were a matter of what the market could bear. Instead, the court found that the copy party is not in the market. They are not included in the contract for services. The court stated that a reasonable fee for a copy of the transcript would not include any amount that compensates the deposition reporter for expedited transcripts. However, the court also stated that the deposition reporter could charge a reasonable fee for expediting the making, certification, and delivery of the transcripts. The case was remanded back to trial court, who again found that the transcripts fees to the copy party were unacceptable. The copy party then asked for attorney's fees for the litigation to establish a remedy for excessive transcript fees. The court denied the attorney's fees and the matter was again appealed. The California Supreme Court ruled in what is known as Stephan 2 in 2011. The court found that court reporters' fees are a matter of public interest, and so attorney's fees to litigate that interest were appropriate. As in Union Pacific case in 1997, the court found that the laws surrounding court reporters' fees were unclear and failed to provide guidance. In 2012, this board asked the Department of Consumer Affairs, Legal Affairs Division, to review and opine on professional conduct implications for a court reporter to charge a copy party expedited fees. The Legal Affairs Division advised that Code of Civil Procedure 2025.510 does not codify the authority for the court reporter to unilaterally charge a copy party fees relating to deposition services, but only for a copy of the completed services. Fees are to be paid by the noticing party unless otherwise ordered by a court. Moreover, the purpose of an expedited fee is to charge for the prioritization and workload of the transcription task ahead of others queued for the court reporter. To charge additional parties for the prioritization and workload would be charging twice for the same service, which is unreasonable and therefore unprofessional conduct. The board accepted the advice and published the policy. However, the policy was not set forth into law. The court struggled without codified guidance. They had to piecemeal concepts of contract law, applicability to those outside the contract, reasonableness, authority to grant remedies, and market economics to rule on the law and fact patterns presented to them. Despite these case rulings, the legislature still did not amend Code of Civil Procedure 2025.510 regarding deposition transcript costs in order to clarify as to allow any type of transcript fees for the copy party. The statute remains as is. Subdivision B, the noticing party shall bear the cost of transcription unless a court orders otherwise. In Subdivision C, the other parties may pay to obtain a copy. And in Subdivision D, the transcript shall be made available to all parties at the same time. Legal's position has not changed. The board is advised that discipline against a licensee for charging a non-requesting party is legally supported. This board cannot enforce a policy. However, the discipline would be supported by the current law as follows. Business and Professions Code, Section 8025, requires licensees to comply with any provision of law related to court reporter duties. Code of Civil Procedure 2025.510 is known to licensees as controlling the law for deposition transcripts. Moreover, this statute is specifically referenced in Code of Regulations, Section 2475. Section 2025.510 authorizes the licensee to collect payment for transcription services from the noticing party. The requesting party is required to pay for transcription services the requesting party is required to pay for transcription services unless other parties are ordered to do so by a court. Other parties may pay for a copy. Legislative intent for Section 2025.510 provides that any other deposition services that are requested shall be the responsibility of the requesting party. Code of Regulations, Section 2470, codifies that professional misconduct shall include any violation of the Shorthand Reporters Act, board regulations, or any code provision specifically governing shorthand reporting. The legislature codified that the board shall work in the best interests of litigants in Business and Professions Code 8015. The board would argue that a fee beyond a stable copy fee is not in the best interest of the litigant. Citation by either party of Stephen 1 would quote, a reasonable fee for a copy of the transcript would not include any amount that compensates the deposition reporter for the cost to expedite the transcription. Moreover, the legislature codified Business and Professions Code Section 8019 that any violation of the act is a misdemeanor. Therefore, the legislature has codified that the law adopted to license, regulate, and discipline the licensees is strict enough to support criminal charges. Therefore, the law fully supports charging a copy party is unprofessional conduct. The licensee and litigant population are entitled to clarity, however. To clearly communicate what is unprofessional conduct to licensees, codification is necessary. This board may codify or attempt to codify any policy that it deems is in the best interest of the public and litigants. Policy determined today, regardless as to what it is, will not change the above law. The above law currently supports that to charge the copy party is unprofessional conduct. Once the board determines its policy, staff will prepare the appropriate codification documents for review at the next meeting. Before the board today, this board must decide its policy on what is or is not professional conduct for a court reporter. May a court reporter charge the copy party for an expedited deposition transcript? If the board finds that no, a court reporter may not charge a copy party expedited fees, the statute supports this position. So therefore, the board may pursue regulatory adoption of the policy into enforceable law. If the board finds that yes, a court reporter may charge a copy party expedited fees, then the board must pursue a legislative change to alter the statute. To adopt regulations that interpret, implement, and make more specific a statute, this board will need to stay within the four corners of the statute. This is even more critical because the Code of Civil Procedure is not within this board's Practice Act. Thus, a regulation must stay within the bounds of Subdivision B, only a requesting party pays for the service unless ordered otherwise. Legal advises that the statutory language of Code of Civil Procedure 2025-510, both B and C, do not support charging additional fees to the copy party by the court reporter. The statutory language does not support charging expedited fees for a period of time or charging all or a percentage of additional fees to the copy party. This board is not prohibited from codifying a policy to change a copy parties, to charge a copy party, but to implement that concept, the statute must then be changed by the legislature. The legislature, however, is not bound by any of this board's preferences. The legislature may codify whatever clarification or mandates that it wishes. This concludes my summary of the legal research. If you have any questions for me, I will be happy to assist you to the best of my abilities. To restate the purpose before the board today, this board must decide its policies on what is or is not professional conduct for a court reporter, which will determine the board's next steps to codify that policy. May a court reporter charge the copy party fees for expedited deposition transcripts? Thank you.
Thank you so much for that very thorough review of the law, Ms. Joffrey. Really appreciate that. Do we have any comments or questions from the board? Ms. Sunkes.
Thank you, Chair. The mission of the board is consumer protection. It's best for consumers to have an unbiased licensed professional, a CSR, certified shorthand reporter who treats all parties equally. And to be fair to consumers, I think the licensee should, in fact, it must charge each party that expedite fee. The transcripts produced are the work product of the court reporter. The expedite is a value-added service. And just like both parties are charged for any other value-added service, real-time, rough drafts, etc., it would be unfair to charge one party and not the others for all services provided. I would point out that in September of 2021, per AB 177, the Government Code Section 69951, which did a couple things, one of which, after 30 plus years, gave official reporters a transcript rate increase. But more importantly to this issue, it allowed for a daily copy fee in the courts, something that's never happened before. It's a daily copy expedite fee. It allows for a 50% expedite fee for transcripts produced on a daily basis, and the courts pay that fee on the original and all copies, just as an example. So I also think that it would be appropriate. I know the issue too would be, I would suggest that if a non-ordering, the side who doesn't order the expedite does not want to pay an expedite fee, that the reporter must produce that transcript within 10 business days.
Thank you, Ms. Sunkes. And just to reiterate again, the question before us is whether or not the reporter may charge a fee, and then legislation and or regulations will have to stipulate any additional guidelines as to specifying what is reasonable, what is, if there are timelines, any additional specifications. Mr. Dodge-Nam, did you have your hand up?
Yeah, sure. And respectfully, I thought a lot about this one, but I think as a public board member, and I focus that our priority is on the consumers of California. I feel that charging an expedited fee to the copying party would not be in their best interest. So I think it could potentially create a bit of an arms race or a pricing race where the one party has more money, they can ask for it and they get an advantage over the other party. Again, as I know Ms. Sunke talked about, we could set some sort of guideline as to the time period that the other party gets it. That would require additional regulation after the fact. But I think that the court reporters should charge an adequate amount. They are very valuable, they are critical, they are worthy, their time is incredibly valuable, and they should charge an appropriate expedition fee to the ordering party without requiring or relying on that some sort of fee also being paid by the copy party. They should charge that upfront fee just to do the work, and it should be appropriate. Then we're not dictating how much they charge. It's market driven. Let them charge what they will. But I think it puts the copying party, the party that doesn't necessarily want it early, at a disadvantage, but as consumers, and forces them to have to pay for something that they maybe didn't want. And as I read the language as well, it says, it says make it available. To me, that doesn't say make it available to order. That says make it available to them. I think the intent there for the consumer is that it's available to both parties to actually have it at the same time, not an option to have it. So I am opposed to allowing the charging of expedited copy fee.
Thank you, Mr. Dodgenham. Mr. Manayan.
I know this is a real topic of discussion. Trying to find a balance, and this is posed to my court reporter colleagues on the board. Is there maybe a balance in between that might work, where any subsequent copies that must be provided could be provided perhaps at a discounted rate instead of a full expedited fee? Is that something you would be open to?
So Mr. Manayan, again,
I'm not sure if that's part of the issue in front of us, or that's part of the rulemaking and legislative acts that would follow.
Yes, that's right. That would be part of any follow-up rulemaking through legislation or regulations. Mm-hmm. And I saw Ms. Brewer had a hand up, and then we'll go to Ms. Sunke after that.
Thank you, Chair. So yes, this issue is a tough issue. I believe it's in the best interest of the consumers of California to have a thriving deposition market and a thriving market of court reporters, competition. And that is a lot of what we're doing with bringing more licensees in. We are going to indirectly affect marketplace rates, competition, those kinds of things. It's critical that court reporters are fair to all parties. Consumers have a right to fair charges, to no party being advantaged over another party. At the same time, it's not conferring an advantage to the consumer does not mean you have to confer a disadvantage to the provider. Consumers don't pay reporters a salary. They don't pay them by the hour. They pay for services. And court reporters must charge all parties equally for services. Now, the greater burden by statute for officials and by practice for an eternity is that the noticing attorney pays a greater proportion. So my response to Board Member Manayan about basically a proportional fee is that I think that's totally appropriate, and I think in most cases, that is how expedites are charged. It's proportional. The actual fee charge for expediting on a copy is a smaller fee than what it is on the original because it's based on the page rate. And the page rate for the noticing attorney is the most. It's always been a cost sharing process, and in an unregulated environment to restrict one thing and not others is problematic. It is problematic because costs can be shift, and maybe that's what everybody's saying they want to do. They want reporters to shift these costs. But it's critical for reporters to be fair, to not advantage any one party. I believe that this is a value-added service. It clearly conveys a benefit, or we wouldn't be discussing it. And I think that reporters should be allowed to charge for this service as they are for every other service, and as official court reporters are allowed to by statute now. So I am really against anybody being disciplined for this. I think that would create a problem. You know, we've got to have an attractive environment for court reporters, and I believe they can charge for the value-added service. Thank you.
Thank you, Ms. Brewer. Ms. Sunkis, did you still have a comment?
Actually, Ms. Brewer addressed the one issue that I was going to raise.
Thank you. Mr. Dodgenham.
So I would say first, again, I totally agree. We want this to be an attractive marketplace, an attractive industry for our court reporters. And that benefits everyone, and all the things we're trying to do are to promote that and drive that. I don't believe that an expedited copy fee is the right way to do that. I would agree with Ms. Brewer if around the notion that, oh, this could potentially hurt our court reporters, they can't earn a living, if we were regulating and capping fees in other parts, but we do not. We let that is an open market. We let the market dictate that. We don't say how much they can charge, and so by keeping that open, the court reporters can charge more for the expedited fee than they're currently charging to the notifying party if they so choose. If they need to do that to justify that cost, they should absolutely charge what their time is worth and what the market will bear. We're not putting any limits on that. My fear in allowing an expedited copy fee is that it would allow one party, which maybe has deeper pockets, to force the other party to spend more money to stay in equal footing in their advantage of what they get. And as consumer protection, that's what we have to protect. We don't want one side saying, oh, I'll happily pay this and I can pay this and I'll get it early. And then again, there are no regulations on when the other party will get it. We would have to do a lot of legislative and regulative work to ensure protection for that, for the copying party. And we're not doing that now. So I say let the charge for that notifying party, or the party that's requesting it, charge an appropriate amount, and then the other side is just paying their standard copy fee. I think that is more in line with what we're doing. And again, I think we talked about, and I had even proposed it myself at our last meeting, maybe we could dictate the percentage that can be charged to make sure for the copying party, so it's not so much. We're not in that business. We're not sitting there setting those percentages or those rates for them. And I don't think that's the kind of the path we want to take to overregulate there.
Ms. Jeffrey?
Thank you. I would like to reiterate that any percentage or sliding scale or alternating copy price is not supported by the current statute. Right. Therefore, the board would need to pursue legislative change. And again, the board would then lose control over how the legislation is adopted. Currently, as Mr. Dodgenham said, the cost to the requesting party is not limited nor regulated. It is what the market could bear. Being a regulated entity, the legislature has dictated that the copy party only pays for a copy and that services are borne by the requesting party. To alter that, we would have to move into legislative change, at which point we could lose the ability for the market to bear whatever the requesting party wishes to pay, and instead the legislature could actually set guidelines, caps, or other mandates upon what a court reporter could charge for any expedited fees or services at all.
Ms. Jeffrey, so at this point, what are the two options that we have to move forward on?
Right now, the codified law, and that is statutory law, a regulation can only interpret statutory law. The statutory law states that a copy party must only pay for a copy. Any requested services shall be borne by the party requesting the services. What the delineation of those costs are, whether or not the requesting party also covers any additional expedited copy rates, will be up to the contract between the requesting party and the court reporter. The law is set that way, and so our options to regulate would be to stay within those boundaries. We could regulate and clarify that the requesting party must not only pay for the expedited fees, but also any expedited fees that would have previously been covered by the copy party. We can state simply that the requesting party will pay for the requested services and a copy party shall not. Or we can somewhat move within those boundaries, but at no time can the costs move over to the copy party other than the copy of the transcripts, which would be the standard copy. Also, we mentioned the 10-day waiting period. That is also not supported by statute. That would have to be a legislative change. So for this board to maintain full control over this policy, it would have to maintain the position that the requesting party and the requesting party alone bears the costs of the requested services. If this board would like to create a timeline of when a non-paying copy party can receive a transcript, subdivision D would need to change. If this board would like the copy party to pay any portion, subdivisions B and C would need to change, or a entirely new subdivision, I believe it's J, I believe this goes all the way to I, J would need to be added to specifically address expedited services. And at that time, upon submitting the proposal to the legislature can accept, deny, accept in part, alter, reverse, go completely opposite, or refuse to adopt any position that any position that the board has put before it.
Thank you for that.
Thank you, Ms. Joffrey. And to be clear, that is the case with any legislation that the board may put forward in regards to any policy, right? Yes.
Yes, as a regulatory entity, this body's power, so to speak, is not only in enforcing the law that is vested to it by the legislature, but in interpreting and implementing the law that the legislature has given it. So that is where the board speaks as an expert in this area, and the board speaks on behalf of the on its informed decisions on the public and on its licensees. The board does not control the legislation. The board can only request, but then ultimately it loses control over the legislation because that is not dictated by this board. So yes, it maintains full power, but must stay within the authority granted to it by the legislature to regulate. Anything beyond what is codified in statute must be changed only by the legislature.
Thank you, Ms. Joffrey. With that, I would like to take public comment before we have further discussion.
This is the moderator. The Q&A is now open. The instructions are on the screen for your reference. If you are logged in and would like to participate, click the question mark inside of the square, type comment, send it to all panelists. If you called in, *3 to raise your virtual hand. At this time, I will send an unmute request to Mary Pierce. And Mary, I'm going to set my timer to 3 minutes. Request has been sent.
Can you hear me?
Yes, I can.
Okay, good. I'm going to talk very quickly because I have a lot to say. I want to thank Robin Sunkeys and Laura Brewer for their comments and Laura's comments specifically at the last meeting. I agree with their position. 2025-320B states that all services and products offered shall be made available. With all due respect to Mr. Dodge Nam, be made available is not the same as shall be provided to. Someone orders a rough draft, I make that available to an attorney to order that product. If they decline it, I don't charge them. I agree, unconscionable charges should not be put out on expedited copies, and you absolutely cannot charge someone for an expedite if they do not request an expedite certified copy. You don't have the right to unilaterally do that, but this is absolutely an added service with added value. And just like the rough draft and the real time, where all attorneys must be charged the same, or at least they cannot, the second orderer cannot be charged more than any other party. So they can decline the option to order an expedite, but it's in some way, I think, restraint of trade for us to provide this added service to second and third copy orders for them to benefit from the first expedite. Yes, the cost of transcription is to be borne by the noticing attorney. Absolutely agree with that. But these added services have added value, and a reporter should be compensated for anyone who receives the added value. So I think that we should be permitted to charge for certified copies on an expedited order basis, and that order must be either on the record or in writing in some other form. It should not be an egregious amount. It can never be more than the original. And as was mentioned previously, copy orders, unless you're cost shifting, which I don't do, should never be more than the original. So the certified copy expedite charge should be the same percentage as the percentage uptick of the original expedite charge, but it would never equal the original expedite charge because the original always costs more than anything that comes after it. And I think that the other party shouldn't benefit from the first person who felt the greatest need for that, if they shouldn't get to ride on the boat for free, so to speak. I think that's all I have to say.
Moderator, I see no further requests for public comment. Would you like me to close the Q&A?
Thank you. Yes. Thank you for that public comment. Ms. Sunkeys.
I would ask Ms. Joffrey, what would need to be done if the board voted that it was appropriate to charge both sides for the expedite fee? You've laid out options, including moving the charge for the expedite charge for the copy to the original and making the original pay for both. I don't want us to get into doing that, but what would need to be done? What would the motion need to be?
So I'm sorry, I don't know if that was compound, but give me one option at a time.
My question is, if the board decides that it's appropriate to charge both sides for the expedite fee, what would we need to do to codify that position? Maybe that's a better way to ask.
There we go. Yes. At that point, staff would then prepare a legislative proposal change that would include language to the effect that the board wished, as well as the support for making those changes and submit that up to the legislature. But that would require legislative change, and the board would then lose control as to what the legislature ultimately determined.
Ms. Joffrey, would then, I guess would depend upon what exactly we asked for in that legislature and what was then, if anything was adopted. But then isn't there an additional step where there would be some regulatory, could you talk a little about assuming that some changes made, then what else is done, say if we wanted to set certain percentages or things of that sort, so in the pricing?
Correct. So part of the legislative change would be unlikely to be successful if it simply said charge the copy party, but that would be an option since this board is talking more in favor of tweaking. For example, subdivision D would say something along the lines of if an expedited is ordered, we'd have to add in the 10-day there. We may have to require that there be a percentage or whatnot. And all of this would need to be built in depending upon what this board wanted to craft and provide to the legislature as to what would be a reasonable expedited transcript fee. So all of that would have to be stacked in. And if not, and it was just they can obtain, they can charge a expedited fee, and that was adopted, yes, we would need further regulation. The more it is set forth in the statute, the less we will need to regulate, but the more that is in the statute, the less we can regulate. So for example, if a legislature adopted that the copy party may pay a percentage, the board could then regulate a percentage up to 80%, up to 10%, a sliding scale based upon income or whatever it is that the board would like to interpret and implement and clarify. The term can charge a percentage. If the legislature adopts they can only pay 1%, then we are stuck with the 1%. And so it depends upon A, what we propose, and B, what is ultimately adopted. More than likely, additional regulation would be recommended to further implement what is in the statute to our specific licensee population and licensee comprehension. For example, as I said at the beginning of my summary, the statute itself references the noticing party. Any party can request expedited transcripts. And they made that clear in the legislative intent when they referred to the requesting party. Any deposition services for any court reporter services at a deposition are to be borne by the requesting party. But in the statute, it says noticing party. So if they maintain that phrasing, we could appropriately regulate noticing party to refer to requesting party. But ultimately, it's not common for the legislature, unless they give us absolute boundaries that we cannot move within. Typically, additional regulation is generally recommended and appropriate.
And follow-up question, what is the overall timing we could expect both for the legislation and then for the regulation changes?
Regulation changes, once submitted, we have a maximum of 1 year in order to finalize those. However, the law does provide, the Administrative Procedure Act for regulations does provide for pre-work to be done and meetings to be held, et cetera, to make sure that any controversial regulations are vetted before being submitted for that 1 year time limit. Also, we would work within the the board's schedule for meetings to review and to provide oversight for the drafts, very similar to what we did for the strategic plan and the sunset. So it could take some time for the regulatory process. For the legislative process, I will have to defer to Ms. Fenner. Generally, once this board determines a course of action, then the executive officer, with the proposal is drafted, I do believe the board would need to approve it. And then the executive officer and Department of Consumer Affairs then seeks a drafting representative, if I'm not, that's not the right word, but basically someone who will sponsor the bill at the legislature.
Thank you.
And the legislative process begins in January. and then typically ends sometime around mid-September, with legislation generally going into effect in the following January, with some exceptions.
So, Chairman, is it fair to say this process of, if we went down that road, could take up to 2 years to process, one for legislative and one for regulatory cleanup?
Yes. So in either way, there will be some time frame essentially, but regardless, I do believe it is important that the board determine a policy going forward.
Oh, for sure. Yeah. Oh, no, of course. I just want to know what that time commitment was, that level of effort. So, thank you.
Ms. Hunkeys.
Yeah, I'm trying to figure out how to word a motion, and I'm not exactly sure if I need to clarify, I need to specify, go into specification, excuse me, about legislation or a regulation or what it should say, or if I could simply move that reporters, that it's appropriate to charge both sides an expedite fee and leave it at that. And with direction, I'm looking at the agenda item. It says discussion, possible action to initiate regulatory or statutory action to codify the board's position on charging expedite fees for the deposition transcripts. Perhaps the motion would be to change the board's position on charging expedite fees. But I believe, I'm just thinking out loud and I apologize. I believe the reason this issue's before us is because nothing was codified. So that's the point, is we need to codify the board's position.
Yes, and I'll turn to Ms. Fenner.
The decision before the board is a simple, I say simple, it's yes or no. Yes, reporters can charge the non-ordering side, or no, they can't. And what staff counsel was clarifying was, if you say yes, they can, then we need to follow that up with legislation. That opens a door, but that is a second step. So it almost doesn't matter. I think her point is, if you want to do that, if you think that is the right thing to do, know that that is the next step. And we all have dealt with legislation and we know where that goes.
Thank you, Ms. Fenner. Ms. Hunkeys?
I move that the board take the position that the expedite fee can be charged to both parties, to all parties.
Ms. Brewer?
Second.
Okay, we have a motion and a second. With that, we will take public comment.
This is the moderator. The Q&A is now open. The instructions are on the screen for your reference. If you're logged in and would like to participate, click on the question mark inside of the square, type comment, send it to all panelists. If you're calling in from your phone, press *3 to raise your virtual hand. Do you have individual identified as Mary Pierce? Mary, I'm going to send a request to unmute your microphone. I'm going to set my timer to 3 minutes. Request has been sent.
I want to thank them for the motion, and just suggest a slight clarification in the language, that not that all parties can be charged expedite, all parties ordering or asking for an expedited service on their transcript may be charged for that added value service.
This is legal, if I may. What we can do in order to avoid kind of a compound motion is start with kind of the basic. We want to charge all parties, and then we can drill it down and provide either motions or instruction to the staff on how to better clarify the wordsmithing and details.
Great, thank you, Ms. Joffrey. Is there additional public comment?
Yes, this is the moderator calling user 16. I'm going to send a request to mute your microphone from your phone. You'll get a prompt. And it takes a moment. You are unmuted.
This is Cindy Vega. I want to thank Ms. Brewer and Ms. Sunkeys. I agree with their position. I also agree with the position of Mary Pierce.
This is the moderator. We have an additional request. Teresa, I'm going to send a request to unmute your microphone. Give me just a moment. And you are unmuted.
Oh, thank you. My concern is I think there's going to be a lot more transcript sharing with council if this is passed. I understand the value of the service and I understand the value of court reporters, but already I see how copies are shared or it's discussed off the record where one party will give another party the transcript. So I'm thinking that both an agency and the court reporter will lose on cost copies.
WebEx Assistant is enabled to save audio highlights.
And that's all I have to say.
The moderator, thank you. I have a call-in user 16. I will send a request. Was this, and I apologize, did we already cover a call-in user 16? This might be possibly a repeat. Is that okay, Madam Chair?
That's fine. Thank you, moderator.
Thank you. I sent a request to mute your microphone. You're unmuted.
Caller 16, I don't know what number I am.
You're
I'm
unmuted.
on my phone.
Thank you.
I'm Cindy Vega. I'm not sure if you heard my earlier comment.
We did. Thank you. Thank you, Ms. Vega.
Thank
Appreciate
you. Okay, thank you. That's it.
This is the moderator. There are no further requests. Would you like me to close the Q&A feature?
Yes, thank you.
Thank you.
Okay, with that, we will take a roll call. Ms. Bruning. Yes, Mr. Dodgenham, before we...
Can I make comments? Yeah, great. I just again want to reiterate my opposition to this motion. And again, I believe strongly our CSRs need to earn a living and charge appropriate fees. I just don't think this is the way to do it. As I look at it, I've looked at it from every angle. The CSRs should charge an appropriate amount for that expediting fee from the requesting party. The way I see it, if we allow the copying charge for the expedited copy, it forces the copying party, the second party, if they don't want to be at a disadvantage, they are now forced to pay for an expedited fee, expedition fee. Even if they didn't need it, didn't want it initially, if the other side's willing to pay for it, now they have to cough up that money as well. Otherwise, they are at an unequal footing. We have no regulation on when they're gonna get the timing they get it, versus the other. That does not feel consumer friendly to me at all. And again, the argument is we want our CSRs to earn a living wage and then, to appropriate for their talent and their work. And there's nothing else we do that prevents that. They can still charge an appropriate expedited fee to be worth their time. We don't put any caps on any of their other fees. I heard great things. Lofty ideas of what we'd like to do to make it a percentage. None of that is reality right now, and I don't think we want to get into the business of managing that. So I'm opposed. Thank you.
Thank you, Mr. Dodge.
Madam
Yes,
Chair,
Ms. Johnson.
due to the bulk of the comment, if we could confirm that there are no other board member comments before we take the vote.
Ms. Brewer.
I do have a comment regarding that. That argument is no different from any other services that a court reporter charges. If a party wants to be on equal footing with a noticing party who orders a transcript, they have to order a transcript and they're charged. If the noticing party wants to order a rough draft or real time and the opposing counsel wants to be on the same footing, they need to order that service. And it's just been drilled as a reporter, it's been drilled to us that you have to treat all parties fairly, and that's in the interest of all of the consumers. So I won't go on. You get the idea.
Got it.
Thank you, Ms. Brewer. Any other comments from the board? Before we take that roll call, I will just quickly speak to my own opinion on this matter. I sympathize with the need for addressing costs for both parties, but we've been speaking for much of last few hours and for years now about the shortage of the workforce, and really at the heart of this issue for me is the access for consumers. And my concern is that by restricting the expedited fees, will be, in either direction, we are putting a thumb on the scale. But if we are serious about addressing the access issues for consumers, I do believe that this motion is the best way forward. Any other comments from the board? Ms. Joffrey, do we need to take public comment one more time, or did we move forward?
Technically, yes. So I would recommend doing so.
Fair enough. I don't know.
And it's always a good time for public comment.
I should know that. One more time, we will take public comment on this issue.
Yes, this is the moderator. The Q&A is now open. The instructions are on the screen for your reference. If you're logged in, click that question mark type comment and send it to all panelists. If you are calling in, *3 to raise your virtual hand. And we do have Priscilla. I'm going to send a request to unmute your microphone. Give me just a moment. Request has been sent. You're unmuted.
Okay, can you hear me?
Yes.
Okay, thank you. Hi, this is Priscilla Galtney. I'm calling as a freelancer right now, and I'm gonna go ahead and echo everything Ms. Brewers, Ms. Sunkes, and Ms. Pierce have said. I feel like the comments that I'm not sure that were just made by the gentleman, it's opening Pandora's box. I mean, to all court reporting services, because as Ms. Pierce stated, a list of, we offer many like real-time rough drafts. I mean, it's the same thing with Expedite. It's a service we offer. So what's to prevent you guys from doing this to all our services? And I don't think, it's unfair to litigants, maybe is what you're saying, as far as they can't afford it, but that's not a court reporter problem as far as the services we offer. That might be legislation as far as, maybe litigants need to do something to make it more fair for them, that is improper going up against, excuse me, I have a cold, against Google, but they aren't entitled to an attorney or anything. That's not, it's just, the whole creating unfair playing field, or they can't afford it. It's just not to be, I don't know. No, I care, don't get me wrong. I'd like to see a fair playing field, but that not my job as a court reporter. It's not to create a plate like oh, they can't afford it, so I have to give you something for free. It's just not a court reporter, it's not that's maybe legislation or something. Anyway, I think that's all I have to say for now. Thank you.
This is the moderator. The next individual, Mary Pierce. I'm going to send a request to unmute your microphone.
Moderator, before we continue, can we hear from council?
Yes.
Thank you, Madam Chair. I did want to make it clear that part of what the legislature has codified and what the legislature has explained in its intent is that it was its intent that the requester shall pay. And there is a provision in 2025-510 that says, notwithstanding 310, this is how we're doing it. And so while other areas of services may be more of a 50-50, the legislature here has codified a specific requester pays process, which is why we would need, this motion would ask us to tell the legislature to change that. Also, as the requester did state, it is the role of the legislature to determine what is fair. If we handle this as a regulation within the current statute, we have control over that. But if the legislature takes it, the legislature determines what is fair. And the legislature can codify that not only under no circumstances shall a copy party be charged, but that expedited fees or additional services can only be X%. Or if you want us to charge the copy party, you can only charge them $5, or whatever it is that the legislature deems would be a fair result for all parties, along with its codified expectation that the interests of litigants as well as the public are to be this board's highest priority. So that's why I want to caution, it's not a matter of codifying what is fair and what we always do. The legislature has codified, they want it differently in this particular situation. And so we are asking them to reverse that. And in doing so, the legislature will do whatever it wishes to do. And it's not within our power or within our desires, but within what the legislature does. So that's where I want to make sure that this board is fully advised of the law, that in this particular situation, regardless of other services, the legislature has codified this particular method. Requesting party pays for requesting services.
Thank you, Ms. Joffrey. If we could carry on with public comment.
This is the moderator, Mary Pierce. I'm going to send a request to unmute your microphone.
Okay, you guys can hear me okay?
Yes.
Okay, terrific. I may need Ms. Joffrey to clarify her last comments because clearly expedite charges are not in the code anywhere. So I don't think that's what she was referring to. And I've already made a comment about, yes, the noticing party is responsible to bear the cost of the original transcription. Now, just two quick comments that I wanted to add. Which is, I think that it would be reasonable and was discussed last time, what would be the delay period to those parties that did not wish to order an expedite? I don't think it should be an undue delay. The last time it was maybe, within, say, 3 to 5 days. I think that's reasonable because if a party can wait 3 to 5 days, they're going to opt to save that money. My rough draft offer last week was 230-page transcript. Well, when am I going to get it if I don't get the rough? Well, it'll be done within 10 business days. Well, I'll just wait. So he had the option, he had the choice. The rough would have been expensive. He chose not to order it, and that's fine. And I've promised him he'll get his 230-page certified copy in 10 days. And again, the certified copy expedite charge should never be more than the original. It should be percentage-wise the same. And the fact that these are being addressed, how is it not being addressed, the practice of some of the firms to do a sweetheart deal on the O&1 and then cost shift to the certified copy orders who have no control over who was selected to take that deposition. So now the O&1 ordering who ends up with the hard copy sealed original to take to court is paying less than someone who gets an electronic copy of a certified copy order. So if that can be done, how can you not at least offer and try to upsell a value-added service such as expedited service on a certified copy? And with all due respect to the gal Teresa from Kuzar and Lexitas, I have never found if you charge reasonable charges that the attorneys will share your product. It's when you do not charge reasonable charges that they start trying to figure out a way around your business practices. Thank you very much.
Madam Chair, would you like me to clarify my comments after that commenter?
Sure, thank you.
I did want to reiterate, as I stated in the beginning, the commenters is absolutely correct. Expedited rates are not in the statute. And that would be part of what we would need to be interpreting through the regulation. However, the statute itself does say that the noticing party shall pay for the services. And as is included in the public documents, I have on packet page 114, under the 2007 statutory amendments, the legislature set forth in its intent that the requesting party shall bear the costs of the requested services. So that is where that link is made. That is where expedited services just are simply a matter of agreement. But for deposition services, the legislature has codified, and its intent is requesting for any service, requesting party pays for the requested services.
Thank you, Ms. Joffrey. Do we have additional public comment?
Yes, this is the moderator. Next individual, Anna Acosta. I'm going to send from West Valley faculty. I'm going to send a request to unmute your microphone.
Jeremy?
Yes, we can hear you.
Great. I am speaking as a professional not representing West Valley College. I want to thank you all for this very thoughtful and thorough discussion of this issue. As a former manager of a co-reporting agency, working with hundreds of lawyers and their staff throughout the world, really, this was something that I was very familiar with. It came up often. And what I learned is that communication is the key to averting conflicts that result in complaints to the Court Reporters Board. It's understandable consumers complain if reporters or agencies send transcripts on an expedited basis with an invoice for with the expedited fees, without first informing those who are present at a deposition, or if they're a party at a deposition, they need to be informed of an expedited request by, say, the noticing party, without informing them of the additional costs, and receiving written agreement, as Ms. Pierce said, of their expedited order and payment thereof, or the decision not to get an expedited copy. To Ms. Pierce's point of view as well, there are agencies who regularly cost shift, charging the noticing party a very small amount, even $1 per transcript, and shifting the cost to the noticing parties, which is unethical and I think illegal. I want to and thank you to Ms. Henke's and Brewer's support of court reporters being paid for the value-added services they provide, and to Ms. Tagati to agree with their point of view as well.
This is the moderator. You had 30 seconds.
I am done. I'm sorry. Thank you.
This is the moderator. That concludes the request. Madam Chair, would you like me to close the Q&A feature?
Yes. With that, I believe we have a motion on the table, and that motion has a second. Ms. Sunkeys, did you have a comment or an amendment to that motion?
I do not. I would just call the question.
Excellent. Shall we? Ms. Bruning, would you call the roll, please?
Sorry, before we do it, can you please just restate the motion? Just, yeah.
You read
Please.
my mind, Mr. Manayan. I have the motion as please move that the expedite fees can be charged to all ordering parties.
Okay.
Moving forward,
Moving forward.
the vote, Ms. Brewer,
Aye.
Mr. Dodgenam,
Nay.
Mr. Manayan,
Aye.
Ms. Sunkeys,
Aye.
Mr. Gotti.
Aye.
Thank you. Motion carries.
Thank you, Ms. Bruning. Ms. Fenner, do we need to do any follow-up direction in regards to that motion?
No, I think that legal counsel is very clear that this is a legislative change. So we will work on legislative language to bring back before the board. And then once that's approved, see if we can find an author.
Okay, thank you. And thank you again, Ms. Joffrey, for all your work on this issue. With that, I believe we need to take a 15-minute break. So let's make it 14-minute and be back at 3:45, if that's all right.
Great.
All right, thank you all. The time is 3:45 p.m. We will be reconvening our December 13 board meeting of the Court Reporters Board. We will continue with agenda item 11, a Judicial Council request for workforce survey.
Actually, we missed 10.
Oh, whoops. Thank you, Ms. Fenner. I'm skipping ahead. Excuse me, agenda item 10, license and certificate reciprocity. Ms. Fenner, would you share an update on the status of OPES's work on evaluation of the CVR?
Yes, thank you, Chair Tugade. OPES has held a linkage study workshop with California court reporters acting as subject matter experts in order to evaluate the Certified Verbatim Reporter certification, which is issued by the National Verbatim Reporters Association. We are currently awaiting a report from OPES, after which we will add it to the agenda of a future board meeting for further discussion. Thank you.
Thank you, Ms. Fenner. Do we have any comments from the board? Any public comment?
This is the moderator. The Q&A is going to be open. Sorry. The Q&A is now open. The instructions are on the screen for your reference. If you would like to participate and are logged in, click the question mark inside of the square, type the word comment, and send it to all panelists. If you're calling in from a phone, press *3 to raise your virtual hand. No requests have been submitted. Would you like me to close the Q&A feature?
Yes, thank you. Okay, with that, now we will move to agenda item 11, Judicial Council request for workforce survey. Ms. Fenner, would you please present this request for us?
Sure. So the board has received a request from the Judicial Council asking us to conduct a workforce survey of court reporters. They are hoping to gain an understanding of the population of the licensed reporters in California and hope to examine changes to the population over time. They've offered to be a source of feedback and input in developing the survey's goals and the questions. Chair Tugadi and I will be meeting with the Judicial Council tomorrow, and we will be able then to bring back any feedback on that request that the board wishes us to share. Thank you.
Is there any public comment?
This is the moderator. The Q&A is now open. The instructions are on the screen for your reference. If you would like to participate, click the question mark inside of the square, type comment, send it to all panelists. If you're calling in, press *3 to raise your virtual hand. At this time, I see no requests. Would you like me to close the Q&A feature?
Yes, thank you. Any comments from board members? Yes, Mr. Dodgenham.
Chairman, just looking for a point of clarification. Are we looking for a motion today on whether or not to pursue this survey or not, or respond to these folks or not? Or are we delaying on that?
So at this time, I don't know that a motion will be necessary. And again, I'll defer to Ms. Fenner here, as we do need more details on the nature of, or the what is being sought from the request. Ms. Fenner?
I think what's more important today, Mr. Dodgenham, is that we get any concerns or interest or any feelings that the board has that we can share. That way we can ask the right questions. I mean, if there's a lot of appetite on the board for us to pursue this, we can explore who's paying for what, for instance. Those are the type of things we want to iron out. I don't think a formal motion, I don't think we have enough information to move forward with a formal motion today.
Great. Thank you.
Ms. Brewer.
Thank you. Yes, I mean, the question came up, or the comment about costs, and that's the instant thing that pops into my head is this is expensive and it's coming out of the request from someone else. So of course there's a concern about cost if we decide that this is something to undertake.
Mm-hmm. Thank you, Ms. Brewer. Ms. Sunkes.
Yes, I question why we would, well, I should say, I think that the pressing issue before us is increasing the number of licensees. And we are utilizing a lot of our staff time and a lot of our efforts on many fronts, many pieces, reciprocity, and of course, I've just drawn like on all the different areas, different ways. We're test formatting, etc. All the different ways we're trying to increase the number of licensees, and I think that I don't see the upside to the CRB, the benefit, I should say, the benefit to the CRB or consumers to take the time away from staff to comply with this request. That would be my thought. I'd be reticent. And I question why they would want this information. And perhaps you'll find out tomorrow when you have your meeting. Thank you.
Thank you, Ms. Sunkes. Fair questions for us to follow up on. Mr. Dodgenham.
I'd just like to echo Ms. Brewer and Ms. Sunkey. I have concerns about the cost and the staff time when we have more pressing things. And exactly as Ms. Sunkey said, what would be the ultimate benefit to us? And even more, this judicial council, is not a authority or a board that oversees us. So I just don't quite see the benefit there. So just have those concerns.
Yes, thank you, Mr. Dodgenham. Mr. Manayan.
Just for the record, echo everything that my colleagues have said.
Thank you. And I would add, we spoke to this earlier in the meeting, but we are required to pursue legislation in order to collect emails from our licensees. And so, as our executive officer has noted, this is just the undertaking alone would be an incredibly difficult or an expensive undertaking, as we've noted, but also a logistical matter to have to mail out, survey responses. And we know that that can be challenging for a number of reasons. And so agreed on kind of getting a little more information on what the purpose would be and what the desired outcomes would be before embarking on this. Any other board comments? Turning to public comment one more time.
This is the moderator. The Q&A is now open. The instructions are on the screen for your reference. If you would like to participate and are logged in, you can click on the question mark inside of the square, type comment, and send it to all panelists. If you are, if you called in, press *3 to raise your virtual hand. I do have Priscilla. I will send a request to unmute your microphone, and I'll set my timer to 3 minutes.
Hello, I'm wondering if you could send that request if it's in a document, if I email you. Is that something I can see? And can I email you or call you regarding how your meeting goes tomorrow? Thank you.